All right, good morning. To the moderator, I have 9:30. Are we ready to go?
We are ready.
Fantastic. Well, good morning. The time is 9:30 a.m. and I call to order the February 4th, 2021 Enforcement Committee meeting of the Contractor State License Board. I am Kevin Albanese, board member and Enforcement Committee Chair. Welcome. Please note that only board members who are members of the Enforcement Committee may participate in this committee meeting. Other board members who are in attendance may observe but cannot ask questions or participate in the discussion. Committee members, if you would like to comment at any time throughout the meeting, please select the raise your hand icon in the WebEx application and turn on your video camera. And if you are on the committee and want to turn on your camera, feel free to do so throughout the meeting. I will call on committee members to speak. When called upon, please unmute yourself, and when finished, return to mute. You'll also need to click on the raise your hand icon to lower your hand after you speak. Joining us today include Registrar David Fote, Chief Deputy Registrar Tanya Corcoran, Deputy Chief of Enforcement Jesse Flores, and our Board Legal Counsel Jason Hirado. Felice, can you please confirm board member attendance and call roll? And yes, I am here.
Okay, Don Giordano.
Here.
Diana Love.
Here.
Michael Mark.
Here.
Richardson.
Here.
Johnny Simpson.
Here.
Nancy Springer.
Here.
We have a quorum.
Fantastic, thank you. Next on the agenda is item B, our public comment section. This item is provided for public comment pertaining to items not on the agenda. To allow the committee enough time to complete its full schedule of business, I will be limiting public comment to 3 minutes apiece. Please note that state law prohibits committee members from discussing any matter brought up during public comment. We are also not allowed to act on any item that is not on the agenda. If you want the committee to discuss a topic not on this agenda, you can ask us to consider placing that issue on the agenda for a future meeting. If you have an application, complaint, or disciplinary charges pending before the board, we ask that you not discuss the details of your case or pending complaint. Committee members are not permitted to receive evidence or information that is not part of the administrative record of the case. If your comments are related to a specific agenda item, you can make your comments now, but we would encourage you to wait until that item comes up for discussion. We will ask for public comment before acting on any item. To the members of the public, if you've joined us on WebEx and would like to make a comment at this time, please either raise your hand or use the chat feature to send us a note that you would like to offer public comment. If you have joined us by phone and would like to make a comment, please press *3 to raise your hand. This will be the same system throughout the meeting for public comment during each of the agenda items. Shelley Jones is our host and moderator today, and she'll be assisting us. And Ms. Jones, is there anybody on the public teleconference line that's looking to make public comment?
I see nothing in the chat and I see no hand raises at this time.
Fantastic. Do any committee members have an item that they would like to place on a future meeting agenda? All right, before we jump into the agenda, I just want to reiterate on behalf of the Enforcement Committee, Missy Vickery for her contributions to this division over the years. Missy exemplified dedication to consumer protection, led this division with great confidence, positive demeanor during your tenure as Chief of Enforcement. Truly, I wish you absolutely nothing but the best in your retirement, Missy. You will be missed. It's been fantastic working with you. I'll give another opportunity. I think everybody said what they had to say during the main board meeting. Is Missy still on?
Yeah, I'm here.
All right. If any other committee members have anything that they want to add that they forgot. All right. Well, thanks again, Missy, and enjoy retirement and time with your family. We are now moving on to agenda item C. Today, we are joined by CPUC Commissioner Martha Guzman Aceves. Did I say that right?
Aceves, thank you.
Aceves, I'm sorry, my apologies. Commissioner Guzman Aceves, along with CSLB Registrar David Fote and Department of Financial Protection and Innovation Commissioner Manny Ramirez are the founding members of the Joint Solar Task Force. Since the first task force meeting in November of 2018, this task force has met quarterly to discuss and develop consumer protection strategies. These meetings have proven to be very successful and resulted in a CPUC proposed rulemaking decision to require investor-owned utilities perform audits of interconnection packets that include solar contracts to confirm, among other things, that contractors are licensed and to make this information available to CSLB. Commissioner Guzman Aceves will also discuss a concept to create a solar residential recovery fund. As reported in the September 9th, 2020 Solar Task Force update to the board and in many task force updates prior, different concept. CSLB collaborated with PUC to review contracts submitted for the utilities for connecting to the electrical grid. These are the interconnection packets. As noted on page 35 of our packet, 153 interconnection packets were reviewed, and it was discovered that 90% were in violation of the contractor's state license law. Most troubling, common violations were some of our more important consumer protection requirements relating to consumer protection notices, start dates, progress payment restrictions, and salesperson registration. At this point, I'm going to turn it over to Commissioner Guzman Aceves to provide further details on this proposed rulemaking decision that will require the investor-owned utilities to provide CSLB information with contract information for consumers participating in the net energy meeting. Ms. Guzman Aceves, the floor is yours.
Thank you very much, Kevin. And thank you all so much for this time. I know it is a precious time for all of you to come together, so thank you for that. And I also just want to thank you for now almost 2 years of partnership through our Memorandum of Understanding, as Kevin mentioned, with both CSLB and the now California Financing Protection Innovation Agency. What I hope to discuss with you today, as was mentioned, are 2 proposals that I'm at the next step is for me to actually put out a formal proposed decision. And so I put out a ruling, what we call a ruling, which has the concepts in them. We have taken comment and are finalizing the end of that for 2 distinct proposals that I'll talk to you about today. So really hoping to, of course, have your support with the overall concept and work through any final details that we need to do before I put out my proposals. And of course, even after they are out, there is going to be additional public comment, so it won't be the end. But it is something that obviously has been driven through the coordination of the task force. Okay, next slide, please. Also, I want to say I am joined by some of my staff today, so if there are any technical questions, I might lean towards them, but I'll walk through this presentation. So these are the 2 concepts, the 2 proposals that are going to hopefully be approved soon and really want to get your input on. The first one is building off of really the majority of the work that we've been doing through the task force and through implementing legislation through Assemblywoman Gonzalez's legislation, which is having requirements. You know, when we first started this effort, the interconnection information didn't actually include the CSLB license. There's no verification that this work was being done by a licensed contractor. So we've come a really long way. And I'm going to get into some of the specifics that are now a requirement. And what really we're doing with this is to get at compliance. We have continued to see, as was mentioned in your package, in your great analysis that you did, there's still a huge lack of compliance with the rules, in particular, a greater lack of compliance with CSLB requirements. So that is the first proposal, is to really get at how we attain greater compliance with the existing rules. The second is a more, I will recognize as a more ambitious proposal, which is to establish a fund to pay for some of the legacy cases and potentially some ongoing ones, but hopefully less so, of customers who have had no remedy. Okay, next slide, please. I'm going to start obviously with the first one. Some of this background was covered already, so I'll just you all know the net energy metering program was updated a few years back. And from that, there was a direction to really look at the consumer protection issues that were arising. And in July, we really kicked it off, and your participation in Huron was extremely helpful as well. Some of your folks were intaking, there was probably about 60, 70 people there with cases that were just looking for resolution. So that really kicked us off. And since then, we did adopt this decision in September of 2018 that created all of the information that needs to be given to the customer. I know we've worked collaboratively with you on that as well. And just everything from really understanding what type of contract they're getting into. We formed the task force that March, and then just there's been a lot of other work. We did a lot of joint outreach as well. Really can't list it all here. But just this last September is when I put out the concept for the recovery fund. And in January, just last month, I put an updated concept out for the compliance proposal. Okay, next slide. When we adopted the decision, our previous decision that required the direction to our staff to work on a citation, and that decision was encompassing of many other things in terms of what to require in the solar package. But part of that was, we told our utility enforcement branch, go develop an enforcement structure for this. Okay, so as part of that, our utilities and our solar industry, but particularly our utilities, petitioned to modify that direction. And the real kind of core issue that we've been grappling with is many of my fellow commissioners want to focus the compliance more on the solar contractors and feel there's a little bit of maybe less focus should be on the IOUs, since they're not really the responsible entity. That's what we've been struggling to find the balance on. How much of this should really be focused compliance at what one would say at kind of the beginning through the contractor, and not towards the end with the IOUs. And in particular, what they suggested is, instead of going out and establishing a citation program that would be citing the IOUs, let's facilitate enforcement that would allow agencies like yourselves primarily to be able to take on enforcement on the contractors. So they proposed in particular that a secure portal accessible for not just ourselves at the PUC, but most importantly for CSLB and eventually DFPI, to have access to the portal to get the data and information they need for enforcement. Of course, they're supportive of the task force and the approach of additional auditing. Okay, next slide. So I took a lot of those comments, as well as comments from the solar industry, to put out a proposal that essentially takes that format that says, yes, the core piece of the proposal is having access to these contracts and ensuring that we can do enforcement. So probably the most important thing about the proposal will be to establish this portal to be able to access all of the information that is needed for enforcement. In addition, I'm proposing that there be additional audits of these documents. So one of the concerns from the solar industry as well as the utilities was, if the utility has to review the package that goes into the interconnection portal, it will slow down solar installations. And so the kind of compromise here is, we're going to have you review just the bad actors, and I'm going to get to that in a bit. And you can let's just go back one more second. You can kind of figure out who those bad actors are in a few ways. One is these audits. If the audits themselves find that there's some compliance issues with the contractors, and they be put on a watch list. The other is any enforcement action that you are taking or we're taking from our own accord if we get a complaint, let's say. So that's the watch list. So let's go to the next slide now. This is just a little bit of background for folks who are not as familiar. The interconnection process really, and what the utility is doing. They receive an application, they confirm all the engineering is complete, there's the implementation with the local governments, and ultimately they provide the permission to operate. Now, the kind of blue shaded, light blue shaded box that talks about the documents, these are, again, all in place. These are things that were legislatively mandated that we've been in coordination with all of you on in terms of what does the disclosure have to contain, what does the guide contain, etc. And so just to kind of recap for you here, these are the things that we're trying to ensure compliance with. Okay, next slide. Just a couple of pieces here on what the solar industry also was supportive of. This concept of them recognizing that some of the contractors really do need to be monitored more closely and potentially, have greater enforcement as CSLB. And so this just really reiterates the process that would be used to maintain a watch list for any violations found out through the audit, and for any complaints, of course, that we have found to be in violation. So kind of talked about that already. It would function to kind of be put on or removed on a quarterly basis. And what it means to be on a watch list is, again, the utility has to now take the time for visual inspection before allowing the interconnection. And if you go to the next slide, we'll just go through that real quickly. So all of those things that were in that light shaded blue box, that's really what they're going to look at. They're going to look to see if there are signatures on the contract. They're going to make sure that all the information that's required for the customer had actually been required. And that's now a package that they're required to do. So it's simple in that regard and should be simple to ascertain if they're not abiding by it. But it does require that visual inspection. And so only those contractors that are on this watch list will be visually inspected. Previously, I had wanted to visually inspect all of the interconnection applications, but that was definitely seen as something that would slow down building these solar panels. So, okay, so this is where we're at in terms of the concept and the compromise that I will be developing into a proposal. Okay, next slide. Okay, so I'm going to shift a little bit, and Kevin, you tell me if I should just get through this or take questions on that first part, but I can keep moving to the next proposal.
The way that we have it set up is I think we want to do the first part of the proposal and then take consideration of the recovery fund separate. So let me then jump in and first off, thank you for the background, Martha. The solar issues, as everybody on the board knows, has been a huge issue for the consumers of the state of California. So any efforts we can do to make this better for consumer, we think is good. So with that saying, with that part of the presentation, first let me open up. Does any enforcement committee member have any question for Commissioner Guzman-Aceves at this point? And if not, then we could get into the motion of what we're being asked to consider. Seeing and hearing none.
I have a question. I have my hand raised.
Oh, sorry, I don't. All right, go ahead.
Okay. My question is on the watch list where you talked about it's reviewed quarterly. Is there a number of times that a contractor can be on this watch list where they're not penalized at a higher level? Say, for instance, they stay on this watch list 3 or 4 quarters. Is there any type of penalty?
That's a good question, Diana. There's no penalty in and of itself that will come from the watch list. The watch list only triggers the full review of the interconnection application. If there is an actual penalty that is developed, it will have to go through most likely the CSLB in their enforcement action. But the watch list itself is only to guide the utilities on when they need to do a more robust review of the interconnection applications from that contractor.
Okay, thank you.
Mhm.
This is Dave Foad. If I could just add a few things, just a little background on what we've accomplished and what we've discovered, and why we think this is important. When we looked at the 153 interconnection packets, we found 4 primary violations that caused us concern. And the first was the contracts, many of them did not include a start and stop date. And that's required by law, and it's critical that you as a consumer know when your project's going to start and when you can expect it to be completed. And the second is the salespeople that are negotiating this, many of them are not registered. Now, initially we started receiving solar complaints. We had a problem with unlicensed practice, but through our work with the PUC, we were able to eliminate most of the unlicensed contractors, but we still have a concern about unregistered salespeople because they're the ones that are negotiating these contracts. They don't have a start date. They don't have the appropriate notice requirements. The consumer is not aware of what they should be considering when considering contracting for solar. And the most troubling violation is where they front-loaded the contract, where they're asking and receiving up to 80% of the contract price before any work commences. And this is driving a lot of our complaints. So what the commissioner is talking about is more of a proactive approach where, one, the investor and utilities would be looking at these contracts, but that information would be available to CSLB staff as needed so that action can be taken to correct that contractor's business practices. And that would be the goal. Have them develop a compliant contract so that there's not a complaint down the road. Currently, we're receiving 90 or more complaints a month, and we need to reduce that number. And so this would be an opportunity to be more proactive to stop the problems that are happening in the marketplace before we receive additional complaints. So I just wanted to provide that background. You have to answer any questions anybody might have.
Thank you, Dave. Any further questions? Because as we understand it, the rulemaking does not include any requirement for CSLB to review the interconnect packets or take enforcement action. But by implementing these strategies, it'll give us the tools and the information so that we can engage in those enforcement actions. And using the strategies, the consumer protection strategies, beginning at the bottom of page 35, the strategies include the review of 600 interconnection packets annually as an effort to proactively identify marketplace practices that may result in consumer harm. These packets will be reviewed to confirm that all applicable laws that apply to licensure, home improvement contract requirements, and personnel are required or being abided by. And if one or more of the identified violations are discovered, staff will review the contractor's complaint history to determine if there is a pending complaint or history of repeated acts. If there is not a history of repeated acts, an education notice could be sent. If there are pending complaints or repeated acts, we could take further actions that are outlined on page 36 of the packet. So what's being asked of the enforcement committee today is that we recommend to the full board to support PUC's enhanced auditing proposal and solar transaction record proposal. So that's what's being asked of this this committee. So if we're in agreement with that, we should get a motion, get it seconded. We could do further discussion of committee members and discussion of public comment, and I'll take that bark as a note of support. Do we have a motion?
This is Johnny Simpson. I would make that motion.
Okay, we have a motion. Is there a second?
This is Michael. Second. Michael Mark, second.
Okay, so we do have a motion to support, recommend full support to the full board. Is there any comments from the committee members?
Nancy Springer has her hand up.
Okay, Nancy, please go ahead.
Yes, I'm just and hopefully I didn't miss it. I was trying to listen there and I was getting some feedback, but I was just curious, like, does CSLB have the staffing to be able to take this on? It seems like this is going to be a lot of work, and just curious if we have the staffing to be able to do that.
Well, this is Dave Fote, and we do. We have a solar task force that's already been developed, and our goal, and if you support this, is to reduce the number of investigations that we're currently conducting. What we found is by looking at these interconnection packets, the actual review goes fairly quickly. We had somebody in the executive office that did the initial review, and it took her less than about 2.5 days to go through all of those interconnection packets. So it wasn't too long. Most of the contractors haven't received a complaint, and so we'll be just sending them, as Kevin mentioned, a educational letter so that they can comply in the future. Others may already have an open investigation, so we'll notify the investigator that already has that contractor under investigation to be aware of this. We don't think it's going to be a significant caseload, and our goal is to reduce the 90 complaints we're receiving each month to maybe 50 or 60. We know we'll still get some complaints, but we want to lessen the workload. So it would be a redirection of some staff that have been assigned to our solar task force, but we think it's well worth it in the long run.
Thank you, Dave.
Thank you, David. And just a follow-up question. As I understand the process, we could certainly review the 600 applications or whatnot, but we're going to get a lot of these called out by the investor-owned utility, because if they start seeing problems, they're going to identify those for us in advance, correct?
That's correct. And we're not under any obligation to do anything with any of them. But if they're on the watch list, that came up earlier, well, we want to make sure that we're addressing that contract, either, again, correcting the business practice or taking the appropriate disciplinary action. So I think the investor-owned utilities will do us a huge favor by reviewing these contracts to make sure that they are a licensed contractor, that they are complete, that they have the notice requirements. So that's a real benefit to CSLB enforcement.
Outstanding. Is there any other committee member comment before we open it up to the board? It looks like Diana Love, do you have your hand up?
No, I do not.
Oh, sorry. All right.
That's Marlo.
Marlo? All right, moderator, is there any committee members with their hand up?
I don't have.
Oh, okay.
Sorry.
All right. Is there any public comment?
Checking right now. I see nothing in the chat, nothing in the QA, and I do not see any hand raises in the public.
Fantastic. Then we have a motion. We have a second. Felice, can you please call the roll?
Kevin Albanese,
Yes.
Don Giordano,
Yes.
Diana Love,
Yes.
Michael Mark,
Yes.
Marlo Richardson,
Yes.
Johnny Simpson,
Aye.
Nancy Springer.
Aye.
Motion passes.
Fantastic. Thank you very much. Now, this takes us to the discussion of a PUC establishment of a recovery fund for net energy metering solar customers. As discussed at the September 2020 board meeting, PUC's plan for a recovery fund would provide restitution to solar customers participating in net energy metering who have been financially harmed and are left with no financial redress. This can occur when a contractor's license has been revoked, where the contractor is unlicensed or is unlicensed. Over the last year, CSLB staff has been instrumental in conducting in-depth analysis, which has assisted PUC in projecting the potential volume of claims and the necessary funds for a recovery fund to be solvent. Based upon the data, it is estimated that the fund would require an initial balance of $1.631 million that will be reduced in the future as complaints reduce. At this point in the discussion, I'd like to turn it back over to Commissioner Guzman-Aceves for her presentation on the recovery fund. Commissioner?
Thank you, Kevin, and thank you so much for all of your support on the last item. It really will be a significant showing of need in our efforts to get to a final product there. So very grateful for that. this one has been, proposal has taken a lot of creativity, a lot of understanding of all of our respective processes, and really where we've come to, although we've had tremendous success working with both CSLB and Department of Financial Protection and Innovation, DFPI. I keep wanting to say their old name, by the way. We've done so much progress, really. We've gotten a lot of restitution for the customers who particularly have been dealing with financial claims. And some of them have had really egregious situations. One particular case I recall that has had up to 3 different financial products on one solar roof, and was like totally horrendous case of over $140,000 of debt that this woman carried. And so there's been some really non kind of work product related claims, and really a huge amount of issues dealing with the financing of these work contracts. So and many of these cases, I just want to say we have done so much, but in some of these cases that remain, there's just no remedy. I'm sure you've heard in previous meetings about some of the contractors that were unlicensed, or some of the contractors that have fled, and really limiting our ability to find a remedy. So we've come to this universe of what we've been terming at the PC the legacy cases of customers that we have not been able to find any sort of restitution for. And although we hope we can look at this as a legacy issue, there's, as we've learned through some of the work together, there's likely going to be some continuation of cases that will continue to lack a remedy through our existing processes. And the majority of these complaints, and whose jurisdiction is broadest, what we are proposing essentially is a construct where our authority allows us to, potentially allows us to collect this surcharge and create the revenue for dealing with these claims. But you all have the expertise really of how to deal with these claims writ large, because you have much more experience here, and you have other remedies that you can pursue prior to getting to kind of this last resort of getting into this hopeful fund. So just a little bit of background there, and I'll walk through this proposal and then give you some of the other dynamics that are occurring with this particular proposal. Okay, so as you all know, there is currently an interconnection fee that customers pay. Usually it's bundled in the whole contract to the utility, and this is about $100 for the most part for most folks. And we put out a proposal, a concept, depending on how much revenue you want to generate, it's going to be in the range of, $15 to $20 on new interconnections. So this is, a concept where future projects will be subsidizing these old legacy cases. And I know you're all familiar with the structures that exist like this throughout our society, really, but that's the meat of the proposal. And through the task force, we were able to hear from some of our sister agencies in other states that have programs similar to this. And I'll mention some of that later, but just to continue through the proposal, we would then select an administrator, which in our recommendation would be the CSLB, to manage these claims and to be able to pay out the appropriate remedy. And this is the link to the proposal, but let's keep going to the next slide here. Okay, so the reason that we really think the CSLB has a key role is, as I mentioned earlier, you're already the expert agency on ascertaining, has fraud occurred, all of the things that you found in your audit, for example. Our folks don't have any knowledge on, that sort of misrepresentation. Certainly, we have no knowledge on workmanship, anything like that. So really, you're the expert agency on knowing what kind of what has really been misrepresented and where is the actual harm. And so we have a payment of anyway, sorry to be rambling a little bit, but the other benefit is folks ensuring that all other things have been exhausted. You've already attempted potentially mediation with the contractor, things like that. Those are most likely not going to be the cases and the claims that go before this fund, because those have a remedy. These are really, and so you're really the expert agency that can show there's no other remedy for this customer, and really the appropriate recovery is through this fund. Okay. Next slide. Okay, so as I said, the proposal for the funding is at the new interconnection, a surcharge on the $100. And based on our derivative math here, we're estimating that, and again, this is the range. So $12 surcharge would approximately connect 1.6 million, given the trends in solar builds right now. But, depending on where we land on this, we would have the appropriate budget. So let me get into some of the dynamics here, which this last bullet points out. One of the proposals has been, this is a concept we've been obviously workshopping and talking about, and some parties will say this PUC shouldn't be assessing this here on the point of interconnection. It should be really at the CSLB. And to be fair, other states do assess the surcharge at their contractor licensing agency. So, there's a couple of ways to look at this in a impartial manner, which is, yes, it is a more direct point of assessment, because that is obviously going directly to the contractor. Certainly, I would argue this interconnection fee is usually bundled as a part of the whole project, so it's not as direct as on the point of interconnection, but it is still really part of the total cost of the project, and it would be a less direct, but still a form of assessing the contractor. And of course, the universe of the contractors that are dealing with the interconnection are just the solar contractors, or those contractors building solar. So there is certainly that discussion. I just want to be really frank about that. Okay, next slide. Okay, so there is going to be this concept. I just want to share from our end. We at the PUC do a lot of surcharging and assessments, and we often create programs that our sister agencies administer. That construct is not actually a new thing for us. I think the harder thing is really that discussion I was just referring to. And this is where I really value your perspective as, leading contractors in the state, is what is the appropriate point of collection for this revenue? And of course, the agreement that there is merit to having this fund. But I think the more crucial question that I anticipate once I have this proposal out is really having a firm perspective from all of you on either agreement or disagreement that the point of collecting this revenue should be through the interconnection, or the other option that's been mentioned is a surcharge on the CSLB license fee. So, and if your recommendation is, the latter, then we should also discuss some opportunities to potentially make that happen. But at this point, what I will be proposing is an assessment on the interconnection fee, and that is really the key question I have for all of you. In addition to obviously the merit of the fund, is your perspective on the point of collection of the revenue. Thank you.
Outstanding. Thank you very much, Commissioner Guzman-Aceves, for that. What I'd like to do to kick the conversation off is kind of flip the script and share what staff's recommendation is, go through those elements, and then we can open it up for committee discussion and questions for you, Commissioner. I think it's safe to say, sorry, my office lights are goofy, so my apologies. I gotta trying to be energy efficient, but somehow the sensors on that side. Nonetheless, what staff's recommending us to do is that we recommend as the enforcement committee to the full board to support PUC's recovery fund for the net energy metering solar consumers proposal with a modified protocol so that contractors are subject to these complaints when all other remedies have been exhausted, which I think was addressed in your proposal. To the enforcement committee, beginning on the bottom of page 43, the CSLB recovery fund referral protocol has been outlined. Per the proposal, CSLB would refer cases out to the fund that would be administered by a third party. This is not a fund as proposed to be administered by the CSLB. Enforcement management have identified protocol for the identification of solar cases appropriate for this fund. They include that a recovery fund payout would be triggered when a license is subject to a final administrative action that includes an order of correction and the contractor has not satisfied the financial injury. As mentioned earlier in the presentation, there are times when financial redress is not possible through administrative or criminal processes and will require enforcement staff to determine, upon review with the supervisor, whether probable violations had occurred that would present a risk of harm to the public. It's these complaints CSLB will share with the recovery fund that estimated financial injury for the consumer. It is important to note that legislation would be required to compel the contractor to reimburse the fund if the financial injury was not established through a formal disciplinary proceeding or action. So that we will not have the power to require that contractor pay back the fund. However, as noted by the registrar, before allowing a license subject to discipline to get relicensed, that licensee needs to show levels of restitution to the people that he or she may have harmed. So there should be some safeguards there. So with that, I'd like to open it up to the committee for discussion, and perhaps it could be a two-part discussion. We can first hopefully all agree that this consumer harm, the financial consumer harm, is a big issue for the consumers of the state of California. So the concept of creating a fund for recovery is probably a good thing. I think it's a good thing, and I'd be interested in the committee's thoughts. And if we all agree that it's a good thing, then maybe we get in further detail of the recovery fund as proposed. So with that, does any committee members have any comments, questions, discussion?
This is Nancy.
Comment.
Oops.
Nancy, please go ahead.
I just wanted to make the comment that I think this is a good thing as well. And I just think we should move forward with it. But I just want to put that on record.
Thank you. Any other enforcement committee members?
This is Diana Love. I have a comment and a question. I agree
Please.
This is a good thing also. But what I want to know is if we vote to go with the interconnection fee as opposed to the surcharge, do we still need legislation?
I can take a first shot at that, and it's actually a really critical question. There is always a possibility, even in some of our other programs. One of the other programs that I have under my portfolio is a research and development program where we assess the surcharge, and our sister agency, California Energy Commission, administers the research program. We were challenged on that assessment. we did win. And so there is a possibility that we would be challenged on it. It's something we would obviously, we face kind of continuously in some of our assessments. I think this one is even, some could argue it's more nexus, and some could argue it's less nexus to our taxing authority. So that is a possibility. However, we would obviously work to make it as legally robust as possible. But I do want to also recognize that some of the advocates are also weary of this and are trying to engage the legislature. Not sure, what will come of that, but it may potentially require reinforcement from the legislature. So it's certainly a risk, but I think that is a common dynamic for us. But it is certainly a risk.
So that's something that you would look into?
Yes, absolutely. I mean, it's something we will, obviously our legal division mostly will help us craft it in a way to be as legally robust. Now, let's say we are challenged on it. A court could remand us in different ways to either remedy any faults that we had or tell us that we don't have that authority. At that point, it would, we would then certainly, I would want to work together to go to the legislature for that authority. However, but to your point, if we are going to go to the legislature, then we should definitely be aligned in terms of what we think the preferred point of assessment is. Is it at the interconnection surcharge, or is it at the CSLB licensing?
The reason that I asked the question, I do believe that my take would be that we would get more pushback from licensed contractors as a fee for those that would feel that they may not violate at any point. But if it's an interconnection fee, is something that is done when it is set up and put to operation. Easier process to sell. Thank you for your answer.
Okay.
Thank you, Diana. Any other committee members have any comments or questions?
Michael Mark has his hand up.
Mr. Mark?
Yeah. Yes. Can you hear me? Looks like I have one question. In terms of currently, is there already an interconnection fee at all? And then this is an additional fee to that. And then second question would be, is there a proposed education to the consumers if this fee is going to be implemented? That way the consumers know that this particular fee, if there's something, if all other remedies via the CSLB contractors and is not completed, that they can be directed to this separate funding source.
Thank you. Yes, there is currently $100 fee. It is a flat fee. I should note that there may be some, discussion on that later on altogether, but currently it's $100 surcharge, and the surcharge would be on top of that, so $100 to $115 or somewhere in that range, depending on what the final revenue goal is. And your question on education and outreach is actually a really good one. Our current solar package definitely points people to CSLB if there are issues for follow-up. But that's a good point. I mean, something we should maybe elaborate on in our next update of the package. If we're successful, of course.
Okay, thank you.
Any other committee member questions? I would just like to throw out, and I don't mean to put you on the spot, Dave, but the thought of assessing a licensee, I think, to generate the $1.6 million necessary, Dave, that's probably a non-starter, given the universe of contractors that are performing this work. Is that a fair statement, that would be a real big challenge?
That's an accurate statement because the B general building contractors can install solar, the C10 electrical contractors can install solar, and then of course the C46s. So it would be very difficult to establish how many of the Bs are installing solar. I mean, that would be an enforcement problem. We have over 100,000 general building contractors. And if we do a recovery fund just for solar and we assess that on all of our general building contractors, there's likely going to be strong pushback.
All right. Thank you, Dave. Does the committee at this time wish to make a motion and second, and we can conduct further committee discussion and public discussion before taking a vote?
This is Johnny. I would make the motion to accept the staff recommendation.
Okay, there's a motion. Is there a second? And the dog doesn't
Nancy.
count as a second.
This is Nancy. I'll do the second.
Okay, so we have a motion and a second. Is there any further committee discussion?
This is Diana Love. I just have one question.
Please go.
Based on the fact that it was stated that there is already a current $100 flat fee, do we need to modify the motion at all? Because it sounds like we're making a motion to do a recovery fund, which I understand, but we're also saying that we have something already in existence.
So what our motion is today is to recommend to the full board to support PUC's recovery fund. So PUC is going to be the one, they're going to go through those exercises to do the rulemaking. We're just going to recommend to the full board. So it's not our fund, it's not our fee. Am I correct in saying that, Commissioner Guzman-Aceves?
Yes, but I think maybe Diana's question was a little distinct, and maybe I should clarify the existing $100 interconnection fee goes to the utilities for their costs on their end to preparing their distribution systems for accepting that energy from the solar generation. So the $100 is actually has a purpose already. It's going for the utilities costs or interconnecting this solar project. What we're going to do is assess a surcharge on top of it for this recovery fund.
Thank you for that clarification. That makes better sense to me.
Okay.
Fantastic. Any other committee discussion? Any public comment?
This is the moderator, and just to remind people, if you'd like to make a public comment, you can utilize the chat feature. If you're calling on your phone, you can select *3, or you can utilize our Q&A feature using the instructions on the screen. Chair Albanese, we did have one question that popped in just at the end of the last one when you were doing roll call, so for the vote. So I'm not sure what it really pertains to.
Yeah, I see that on
see that one?
Yeah,
Okay.
I see that on the chat. That doesn't apply to this particular
Okay.
motion.
And I'm not seeing any hand raises nor
All right.
requests coming in through the chat or the Q&A.
Gotcha. All right. So I'm going to bring it back to the committee, and just speaking for myself as a committee member, I think that some sort of fund is absolutely necessary. These consumers are getting being taken advantage of by some really unscrupulous folks, and as I understand it, it's like whack-a-mole right now. And if this is going to be a fund and an opportunity in conjunction with what we passed earlier to provide some relief for our consumers, I think that's important to do that. I don't want perfect to get in the way of something that's good. And I think this is a good start. I, for one, would love to consider other opportunities, whether it's through surety bonds with the people that are doing the interconnect, the contractors, perhaps some sort of mandate that they provide surety either for that consumer or for this fund to really target the people that are causing the harm. And, creating a state recovery fund, I think, has some concerns for me. I think it's a good start. So I'm absolutely going to vote in support of moving this to the full board. And certainly we could have further discussions, but we need to do something. And again, if this is a good approach, I don't want waiting for the perfect thing, because we do need to do something urgently. So if there's any other committee comment, I would entertain those. Otherwise, I'm going to send it over to Felice for a roll call vote. Felice, can we get a roll call vote on the motion? And I am an aye.
Don Giordano,
In favor.
Diana Love,
Aye.
Michael Mark,
Aye.
Paula Richardson, Marlo,
Aye.
Johnny Simpson,
Aye.
Nancy Springer.
Yes.
Motion passes.
Fantastic. Well, there are no other items on the agenda for today, so we are going to adjourn this meeting, take a short break, and if Legislative Committee Chair Augie Beltran is on, if you want to let everybody know what time you're going to start, we will adjourn this meeting. So do I have a motion to adjourn?
I'll make a motion to adjourn.
I'll
All
second.
right.
Good morning.
We got a
This is
mo-
Augie. We're going to start at 10:30, so about 4 or 5 minutes from now.
Perfect. Ledge starts at 10:30. Felice, you want to do a roll call vote to adjourn, and I am an aye?
We don't need roll call to adjourn.
We're adjourned. Have a great day and weekend, everybody.
Thank you. Take care.